Good afternoon, everyone. As we gather here today, the University of Saskatchewan acknowledges that its main campus, including the College of Law, is on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I'd like to begin by thanking McKercher LLP for sponsoring our lecture series, the McKercher LLP Lecture Series, of which the Gertler Lecture is a part. We're very grateful to McKercher for their partnership and support of the college and legal education. Their sponsorship lets the college present a wide range of speakers to the law school community. Today's lecture in particular is the Gertler Family Lectureship in Law. This lecture is devoted to subjects related to law and ethics and is generously funded by Dr. Maynard Gertler, a distinguished graduate of the University of Saskatchewan, an internationally renowned cardiologist as well, and he founded the lecture in honor of the McKercher family of Saskatoon. Our speaker today is Dr. Teresa Scassa, whom we're very fortunate to have as the next speaker in the Gertler series. Dr. Teresa Scassa is the Canada Research Chair in Information Law and Policy, a faculty member at the Centre for Law, Technology and Society, and a full professor in the Faculty of Law Common Law section at the University of Ottawa, with a cross-appointment to the School of Information Studies. Dr. Scassa's research explores the intersection of law and technology, and she draws on interdisciplinary approaches and networks in her work. Dr. Scassa is a member of Canada's Advisory Council on Artificial Intelligence and a member of the Law Commission of Ontario's advisory panel on the AI in Civil and Administrative Justice Project, and she currently sits on 2 data policy-related working groups in Ontario. She's a past member of the Canadian Government Advisory Panel on Open Government and the External Advisory Committee to the Privacy Commissioner of Canada. Dr. Scassa earned her undergraduate degree in Common Law and Civil Law from McGill and her LLM and SJD in Law from the University of Michigan. So please join me in welcoming Professor Teresa Scassa.
My topic today lies at the intersection of medicine, health, and ethics, and it addresses some of the thorny questions that are arising around personal and health AI. These are issues about, on the one hand, the protection of privacy in an AI-enabled healthcare context, and on the other hand, about how to provide appropriate access to data to support quality research and innovation in healthcare. You'll note how I begin with privacy, since privacy law is a key element in health data governance, and it plays a very significant role in determining when data can be used in research and by whom. But my main argument is that privacy alone is insufficient to address the issues that we face in this space, or at least privacy law as we've known it. We live in a moment where talk of AI is everywhere. That's not surprising. The AI revolution is expected to be transformative and disruptive of society in the same way that the Industrial Revolution was, perhaps even more so. Governments are making adoption of AI across public and private sectors a priority. We're already seeing disruptions and the displacement of humans in the labor market. In the healthcare context, AI promises to do many things and in many different ways. It's already used for research and development, particularly in the private sector. We anticipate advances in robotics, remote healthcare delivery, diagnostic tools, predictive medicine, personalized medicine, just to give a few examples. AI can also help us to do things better, identifying clinical trial subjects, streamlining hospital workflows, and triage of patients. AI medical scribes, an application of generative AI technology, are now already in use by physicians across Canada to ease their administrative burdens and free up more time for patient care. As these tools evolve, they'll also be suggesting diagnoses and recommending courses of treatment. It's really just a matter of time and before they are engaging in those, before they have that functionality. It's likely that AI will fundamentally transform what we understand as healthcare. It'll provide us not just with new medications, diagnostic tools, devices, and prosthetics. It will also change how we deliver healthcare, to whom we turn for medical advice, And these are just for an example. This is totally informal, and nobody's planned this, but people are using ChatGPT for medical advice. In this Reddit thread, people are really enthusiastic about ChatGPT as an alternative to a doctor. And even the roles played by medical professionals within the healthcare system. And so this transformation is already underway. AI systems require data, and health AI systems depend on health information. Without a doubt, AI in healthcare both accentuates existing privacy and data protection challenges and creates new ones. It places in high relief issues of access to quality data for research and innovation purposes. It also accentuates complex issues of health equity as we consider whose data are used, for what purposes, and under what conditions. What I hope to do today is to explore some of these challenges with you before outlining where we need to turn our policy attention. So I start by asking the question, what do we want when we think about our health information, privacy, and AI? And I would argue that we want three main things. First, we want to control our own health information, including being able to keep it private, to access it, and to share it. Secondly, we want to benefit from and not be harmed by uses of health data collected from us. And thirdly, we want to contribute to meaningful health research that will improve our lives and the lives of others around us. So let's start with the first one, our desire to control our own health information, including being able to keep it private, to access it, and to share it. Our personal health information that we share when we seek medical care is sensitive personal information. In the 1992 Supreme Court of Canada decision in McInerney and MacDonald, which explored the nature and extent of a patient's right to access their health records, Justice Laforêt centered the interest of the individual when he stated, "Of primary significance is the fact that the records consist of information that is highly private and personal to the individual. It's information that goes to the personal integrity and autonomy of the patient. Yet physicians are also required to document their interactions with patients, and they have an interest in their records. Justice Laforêt acknowledged this, suggesting that there was a fiduciary relationship between a doctor and a patient with respect to the recorded information. And he stated that the information conveyed is held in a fashion somewhat akin to a trust. While the doctor is the owner of the actual record, the information is to be used by the physician for the benefit of the patient. The confiding of the information to the physician for medical purposes gives rise to an expectation that the patient's interest and control of the information will continue." In this account of the interests at play, the patient's right to privacy coexists with the physician's rights in their records. There's a stewardship role for the health information trustee, but it's with respect to the individual patient. These are important assumptions on which our health information privacy laws have been built in most provinces in Canada, including Saskatchewan. These laws prioritize patient consent and rights of access to their personal health information in the hands of healthcare providers. Health information statutes also recognize additional interests in health information, and none is perhaps more important than the interest in health research that's necessary to advance health sciences and healthcare. Personal health information laws set out the terms and conditions under which university and hospital-based researchers can access personal health information for research purposes. These terms and conditions typically require ethics review, which introduces another important layer of governance of the uses of personal health information. It requires reflection as to the potential harms and benefits of the proposed uses. Provincial health privacy laws address health information that's closely tied to the traditional healthcare system. In these laws, personal health information is typically defined as information about an identifiable individual relating to their personal or mental health, information about health services provided to that individual, and information collected directly or incidentally while providing health services. Because on this view, it's data collected in the course of providing health services, health data protection laws tend to establish rights and interests in data within this healthcare context. And for the most part, those who collect personal information, or PHI as I'll sometimes refer to it, are healthcare providers or hospitals, often referred to in the legislation as trustees, in Saskatchewan, or custodians in Ontario, for example. It's these trustees who are charged with the responsibility to protect PHI. It's important to note that this is also a highly professionalized context, and many of those within the system are governed by professional bodies and have other obligations of confidentiality with respect to patient information. And this reinforces the privacy rights in the legislation. There's another type of data captured by the health care system, and that's health administrative data. And that's often used to refer to the information collected by the government in our publicly funded healthcare system for the purposes of billing and for the administration of the healthcare system. This is personal information and it relates to health. It's also very important data for the purposes for which governments collect it, the administration of the healthcare system, but the data is also used in a broad range of research activities, such as understanding things such as chronic disease prevalence, population health analysis. It can also be used in analyses aimed at improving the quality of care and the better allocation of healthcare resources. Health administrative data may be governed under personal health information legislation or under public sector privacy laws, depending on the jurisdiction. So having talked about personal health information as collected by healthcare providers and health administrative data, it might feel as if we've covered the basic health data ecosystem, but we haven't. At the time of McInerney and MacDonald, we were still largely thinking about health data within a paradigm in which the doctor scribbled notes in a file, and the file was stored in a filing cabinet. Today, primary care physicians enter data into electronic medical records, or EMRs. They do not build or maintain this technology themselves. Instead, they contract with private sector providers. The main Canadian companies are TELUS Health, Well Health, and QHR Technologies. For their part, hospitals work with electronic health record or EHR vendors that include Epic, Meditech, and IBM. Although on one view, these EMRs and EHRs just replace the paper file in a way that offers new functionality without altering relationships between physician and patient when it comes to health data, they do add an important new layer. EMR and EHR companies amass a substantial volume of patient data from multiple physicians, hospitals, and practices. They do so as agents of the data custodians or trustees under health data protection legislation, and they must comply with the requirements of such laws, but these laws only apply to information about identifiable individuals. De-identification, a technique used to protect privacy, when carried out according to the standards required under health data protection legislation, can move these data out of scope of such laws, allowing for the commercialization of rich de-identified data sets for a broad range of purposes. And I've just given you an example from Saskatchewan's legislation, but it's similar in other provincial health information statutes, that if the information is properly de-identified, then it comes outside the scope of governance of the provincial health information legislation. So some of the purposes for which these de-identified data sets will be used will include research and innovation. Indeed, companies like Epic, this is just one example, are using their EHR data for AI-enabled health and health system research. But there are no guarantees about who will be carrying out this research and innovation or for what purposes. And Cheryl Spithoff has written about the markets for de-identified health system data in a really interesting article that looks at this burgeoning health data ecosystem. Further, it should be noted that although we still maintain a publicly funded healthcare system in Canada, the role of the private sector within it continues to expand. For example, many primary care physicians now operate under the umbrella of private sector companies, chains of health clinics, and these chains are getting larger and larger. These companies provide administrative services to the doctors, including electronic medical record systems, or EMRs. With data collected from multiple affiliated physicians, these companies can amass important collections of health data that can be mined for insights or that can be anonymized for commercialization purposes. Similarly, data held by vast pharmacy chains is an important source of both anonymized health information that can be commercialized, or it can be used by the pharmacy chains themselves to derive insights that can be used for various purposes, including marketing. Again, Cheryl Spithoff has written about these practices in her article, and they reflect the growing relationship between healthcare practitioners and private sector companies. Her research finds that patients are largely unaware of these practices and are absent from decision-making about how their data may be used and commercialized. In addition, the health data ecosystem is increasingly impacted by the variety of private sector products and services that both collect health-related data from people and in many cases use AI to analyze the data and generate reports and recommendations for users. These data can be used in a variety of ways, including in health-related research. For example, there are any number of wellness wearables from Fitbits to Oura rings, see some of these up on the screen here, that capture massive volumes of health-related data about our exercise levels, our vital signs, our sleep patterns, fertility cycles, and they collect this data on a regular and continuous basis. Many of these apps also allow users to contribute additional data about their moods, their diet, and so on. The apps may collect location and other data as well. These data are used to generate analytics and reports for users, providing tips and advice on topics such as diet, sleep, when to exercise, peak fertility periods, and so on. These data can also inform health and private sector research, including by the wearable company itself or by partners or to those to whom the data may be sold. As wearables become more precise, we can expect the data they collect to become more valuable. Genetic data also have the potential to reveal important insights about our health. Once collected and analyzed exclusively within the healthcare system for at least a decade, now actually it's more than a decade now, I double-checked, it's almost 20 years. Now, it's been easy to drop a cheek swab in the mail to a direct-to-consumer genetics company. Although the primary interest of many who do so relates to ancestry, these companies also offer additional services providing analyses, reports, and insights about disease risk and health. These companies may also provide lifestyle analyses based on genetic data and may sell customized programs or offer products linked to these analyses. There are also entire other categories of data that we do not normally think of as health data, but that with data analytics can become health data. A prime example is social media data, which has been used for a broad range of health-related purposes, including identifying those with mental health issues. Biometric data, including facial data and gait analysis, are being mined to provide insights about health, and these data can be extracted from a broad range of sources that were not necessarily created for health-related purposes, including from online photos and videos. And here you just have some examples of research studies relating to social media and mental health, but also biometric analyses of biometric data. The proliferation of data and data sources, as well as the demand for health data for AI research and innovation, puts us in a situation in which we have two-tiered, at least, access to data with potential implications for quality, ethics, and inclusion, as well as for where and how health research will be conducted and by whom. The highest quality and most complete data, at least for now, are those collected within the healthcare system. It's patient healthcare information and health administrative data. As noted earlier, these data are governed by highly protective personal health information and public sector data protection laws. Routes for access to these data give preference to hospital and university-based researchers and are often slow and challenging to navigate. Use will require Research Ethics Board approval, which may be given under strict conditions. By contrast, de-identified data, as noted earlier, are increasingly slipping the boundaries of our healthcare system with greatly reduced privacy and ethical oversight. The collection, use, and disclosure of the other categories of health data, such as app data, are governed by private sector data protection laws and frankly will receive less privacy protection than personal health information under personal health information legislation. Their use will also not come with mandatory ethics oversight unless used by publicly funded researchers. Although they are also in many ways of lower quality, this does not mean that they will not be used to innovate within the health AI space, particularly if they are faster, easier, and less complicated to access. This review of the health data ecosystem reveals that the growing role of the private sector in the delivery of primary care means that data derived from our interactions with the healthcare system is increasingly being used and governed outside of personal health information legislation. Similarly, the growing volume of health-related data that is collected outside of this system is governed by private sector privacy laws, which place fewer restrictions on its use and sharing. This can be a problem if we want to control our own health information, including being able to keep it private, to access it, and to share it. And so that brings us to the second consideration, that we want to not be harmed by the uses of health data collected from us. Personal health information governed through our trusted public systems requires Research Ethics Board approval before access is allowed, and REBs require and maintain strict protocols around privacy and other important data governance issues. The same systems may not be in place for anonymized personal health information data sets that make their way into the commercial private sector. I'm not saying that this data is necessarily used unethically or improperly. Many large companies have internal data governance protocols and processes, including some form of ethics review, but there is much less transparency and no external oversight. Cheryl Spitoff, for example, has written about the use of pharmacy chain data to identify patients and the prescribing physicians who might benefit from new treatments being marketed by Big Pharma, connecting pharmaceutical companies to the physicians to create a conduit for their products to the patients. This type of program operates in an ethical gray zone. One can also argue that any such uses of health data without appropriate transparency are harmful to individuals who simply may not want their health information to be used in these ways, but are unaware that it's occurring or what they might do about it. This raises the issue of whether and how individuals should be able to opt out of having their data be part of anonymized data sets. Alison Paprisa and others have examined issues of social license in healthcare research and have found that people are much more willing to share health data with public sector researchers than with those in the private sector. And there are similar conclusions reached by others, and I've put another article up there as well by Bart and Al. The risk of re-identification of individuals within anonymized data sets is also a real issue with AI technologies. For example, large data sets can be analyzed to look for rare disease markers, and if patients can also be re-identified within these data sets, what implications might that have for those individuals? Some data protection laws are now being amended to include prohibitions and penalties for deliberate re-identification, but this is not yet universally in place, and it's not clear how much of a deterrent effect such penalties will have, or how transgressions will be identified or proven. There may be other types of harm that our laws might need to recognize as well. As we've seen, privacy laws are very individual-focused and depend on things such as individual consent and control. Yet the massive amounts of data we have about others are used to profile us in many ways and for many purposes, and can be used to predict our preferences and predilections. Some scholars argue that we also need a concept of group privacy to address the ways in which the data about others, over which we have no control, is used to make decisions about us. Data about groups and communities can also be important in the healthcare context. In some cases, certain diseases may be more likely to manifest themselves in people with shared genetic characteristics. In other situations, researchers may be interested in studying the health effects on populations of living close to certain types of industrial operations. This raises questions about the rights of those groups or communities to have a say in how their collective data may be used. In Canada, the evolving Indigenous data sovereignty movement has identified health data as a key element of data sovereignty. For Indigenous communities, data sovereignty is about more than just having a say in whether health data are used by researchers. It's about controlling access to the data, about being able to participate in identifying and formulating research questions, and about ensuring that any research returns benefits to the community. It's also about education and training to build research and data science capacity within communities. Although in the context of Indigenous communities, data sovereignty is clearly tied to self-determination goals, similar concepts of community-based rights are being asserted in other contexts as well. The Black Health Equity Working Group in Ontario, for example, produced an interesting and important report that asserted community-based interests in ensuring that data be used ethically and appropriately to create pathways for advancing equity and for improving health outcomes for Black communities in Ontario. This report goes so far as to make a data sovereignty claim extending to community rights to govern the collection of data, its management, analysis, and use. Such community-based claims around data governance also raise issues about data justice more broadly. Data justice is defined by Lynette Taylor as, and I quote, fairness in the way people are made visible, represented, and treated as a result of their production of digital data. It's this mass-scale production of data and its use in powerful and increasingly ubiquitous AI technologies that make it even more important. In this sense, data justice goes beyond privacy, although privacy can be an element of fairness. Taylor also centers anti-discrimination principles within the concept of data justice. Discrimination in health-related AI is a significant concern. One reason for this is that AI systems are built on available data, and biased data will produce biased outcomes. Health data may be biased if certain groups of people are excluded from data collection, perhaps because they've been overlooked in clinical trials or research studies, and those studies have not been designed to take diversity into account. For example, some cardiological symptoms manifest differently for women than for men. This has led in the past to women's symptoms being overlooked or misdiagnosed, a phenomenon that has skewed and distorted available data. Health system data can be biased because social and economic factors may mean that people from some communities have less access to health care or are less likely to be understood properly or to be taken seriously by healthcare providers, all of which impact the data that are collected. Distrust of the healthcare system may mean that individuals from some communities may only seek medical attention when their conditions or diseases are much further advanced, which also impacts the health data that are collected. We already have examples of how such data can distort the outputs of AI systems, perpetuating systemic biases in new ways. One way to address bias and discrimination in health data used in AI is through appropriate data governance requirements that are part of risk regulation legislation, but we still have no such laws at federal or provincial levels in Canada. Another way to address bias and discrimination in the use of health data is to use disaggregated data. In other words, data in which markers, gender, ethnicity, and so on, are not removed as part of the de-identification process. Not only does this allow researchers to see where different factors lead to different outcomes in the context of AI analyses of data, it's also possible to identify circumstances which are producing biased outcomes for different communities. Some governments have passed laws, and this includes BC and Ontario, to address the collection of disaggregated race-based data, something that must be done with great caution and sensitivity. Others, and I give the examples of Alberta and Nova Scotia, have put in place policies to support the development of standards to address these issues. CIHI, or the Canadian Institute for Health Information, has issued minimum standards for the collection of race-based and Indigenous identity data for collection and health reporting in Canada. These standards and others rely upon solid data governance practices and community engagement. This is a challenging area, but it reflects how data governance issues may need to go beyond privacy, particularly in the health space. So, returning to the idea that we want to benefit from and not be harmed by uses of health data collected from us, whether and how we do so will depend only partly on privacy laws. It will depend on acknowledging collective relationships to data. It will also depend on sound and ethical data governance principles, ones that apply not just to personal health information in the hands of trustees or custodians, but also to de-identified health system data that increasingly escapes the health system. Although we consider public and health sector data to be of the highest quality as data, there needs to be an acknowledgement of the efforts being made on the data governance front to address other ethical and data justice issues through broader governance in this space. This may slow research down, and we will need to come to terms with how big a gulf we're willing to leave between public and health sector data and uses of anonymized data without formal governance requirements, as well as uses of health data from a growing number of private sources. And so this lack of attention to governance, particularly in the private sector context, creates or widens the gulf between the speed and ease of access to health data for research in public and health sectors versus the private sector. The third question or the third issue, that we want to contribute to meaningful health research that will improve our lives and the lives of others around us. Research shows that if appropriate safeguards are in place and if the researchers are trusted, there's a much greater willingness to share personal health information for health research, and many do so with enthusiasm if asked. Yet the problems revealed from the above discussion are that on the private sector side, there's access to all kinds of health data of varying qualities with little or no mandatory governance compared to the public sector side. Much of this escaped data may not be easily accessible to hospital and university researchers because it's proprietary and either tightly controlled or costly to access as a result. It may also simply not be of the best quality. At the same time, our health system data, which is of very high quality, is governed by frameworks that put personal privacy first and that often only indirectly recognize a public interest in research. This public interest is generally not framed as an independent social value pursued by the government. I offer as evidence of this approach the following quote from the preamble to Saskatchewan's Health Information Protection Act. To the effect that the primary purpose of the collection, use, and disclosure of personal health information is to benefit the individuals to whom it relates, right? So, and this is typical of other personal health information. It really, based on the McKercher and McDonald approach, centers personal health information around the identifiable individual or the individual data subject. And I want to contrast this with the opening statement in the new, and this is very new from 2025, earlier in 2025, the new European Health Data Space Regulation, which speaks explicitly about the public interest goals to be served by it. A lot of text there. But I just want to draw your attention to how it talks about, in the very first recital of the directive, the goal being to establish this European health data space to improve natural persons' access to and control over their personal health data, so that element is there in the context of healthcare, as well as to better achieve other purposes, including the use of electronic health data in the healthcare and care sectors that would benefit society, such as research, innovation, policymaking, health threats preparedness and response, including preventing and addressing future pandemics, patient safety, personalized medicine, official statistics, or regulatory activities. And so you have in the legislation that frames this new European health data space, privacy being balanced explicitly against these other important public interests. And that's something that we actually, although our personal health information legislation contains exceptions that make room for health data research, the legislation itself is really framed about the individual data subject as the center of that legislation and about protecting privacy as the primary goal of that legislation. And I would argue that that has an effect on how we manage healthcare system data. So what I'm suggesting here is that modernized personal health information legislation should reassess the interests in data in a data-driven and AI society such that the laws more expressly balance the privacy rights of the individual with a more clearly articulated public interest in health research and innovation. Of course, in doing so, they'll also need to deal with the fact that private sector actors also want better access to high-quality health sector data. Whether and how to facilitate this access and under what conditions and safeguards are also important public policy questions. This can be a way to center ethics and governance as well with the use of these data, including by private sector actors. Finally, we cannot leave privacy laws, at least as they currently stand, to regulate the vast amounts of health data collected by apps and wearables and used in AI. We need mandatory rules for ethical and accountable AI governance. We need AI regulation. The transformation of our society through AI technologies will further blur the lines between public and private actors in the health space. We need to narrow the governance gaps in ways that best serve humans. And so let me finish with a set of a few other recommendations for how to move forward. In terms of privacy protection, we need to acknowledge and address the risks of re-identification in de-identified data sets, especially as we see de-identified healthcare data increasingly commercialized outside the formal protections of our health information systems. Those data protection laws that do not address re-identification through deterrence and enhanced penalties should be amended to do so. Perhaps more importantly, though, we also need to come to terms with the issue of whether de-identified personal health information from our publicly funded healthcare system should ever find itself in the wild and not subject to appropriate data governance frameworks. Failing to address this will make people more vulnerable to misuse of their data, reduce their autonomy with respect to their own data, and will also place hospital and university researchers at a disadvantage as they are subject to governance requirements that are not imposed across all users of healthcare system-derived data. Failing to do so will also mean that collective interests in data, group privacy, and broader ethical concerns are not built into governance frameworks. We need prescribed AI governance rules to address ethics, transparency, discrimination, accuracy, and cybersecurity when it comes to the development and deployment of AI technologies, particularly when they're built using data derived from humans. An effort to put this in place has already failed at the federal level, but we should not give up. In addition, provinces can set rules for the public and broader public sectors. They can also establish procurement requirements for technologies developed in the private sector but used in the public and health sectors. And actually, procurement is a really interesting and important way in which governments can impose ethical obligations on the development of AI technologies. This may seem like a lot, especially as technology continues to evolve at a blistering pace. We're now being told not to stand in the way of innovation, but governance is so important, especially in the context of healthcare and health information. We actually have so much commitment and expertise in Canada regarding the ethical governance of health data that we are able to draw upon. But the rules and frameworks we rely upon need to work, and they need an adjusting for ethical governance needs to happen sooner rather than later. So I'm going to stop there and open it up to questions and discussions. I wanted to leave some time for this because I think our health information is a subject that should concern and interest all of us. I don't know if anyone has any questions or wants to jump in.
So with the collapse of 23andMe, and there were real possibilities of all that data being sold off as an asset in insolvency proceedings, a couple of questions. One, is that legal? You've probably signed a license which says it is. But the second question is, how difficult is it to re-identify someone from de-identified data? Because that's the real challenge, right? Is
Right.
it, can you, and do they do it by class, race, whatever, or can you actually get down to the individual?
Okay, yeah, and I'll treat those as two separate questions because I think they are. 23andMe, wow, you know. That was one of those things right at the start that, you know, when this direct-to-consumer genetic testing, a lot of people in the privacy space, when they kind of heard about it, said, wow, what could go wrong, right? And then it went wrong. They had a data breach, a significant data breach, which was bad enough. The data breach spurred class action litigation, which drove the company to bankruptcy, and then, as the dean has pointed out, then also led to the need to sell their assets to try and address the bankruptcy issues, the insolvency issues. And so this put people's data significantly at risk. I mean, it is, people contributed this data under user agreements that nobody read the terms and conditions for. And you had attorneys general in the United States and states that actually had privacy laws sending out notices to the public saying, you can opt out, but you have to do it now. Like, there's a narrow window of time, get it done. And so you actually had public officials telling people to protect your privacy, your private genetic information from being sold, you need to act now. So I think that we don't realize how vulnerable our data is when we share it with private sector companies. We don't necessarily read the terms and conditions, and they operate on a pretty wide spectrum of practices, with some being very concerned about privacy and having fairly good safeguards in place, and others not being particularly concerned at all and actually having commercialization of the data as an objective. And so this is a real issue in terms of privacy and healthcare data, particularly as this data becomes more detailed and more refined. And what could be more detailed and refined than your own genetic data? But some of these fitness or health app companies are getting better and better at collecting high-quality data about individuals, which can have a real value. Now, in terms of the issue of re-identification, because sometimes I've mentioned it's de-identified primary healthcare system data that's being commercialized and sold, but also the data from these app companies can be commercialized and sold, sometimes de-identified, sometimes in identifiable form. But assuming it's de-identified, in the context of AI, re-identification is becoming easier and easier. In fact, some say there is no real de-identified data anymore, that there's always going to be a way to re-identify it. And if you're talking about the healthcare context, you've got two factors. One is that the data is ever more sensitive because it's it might be your genetic data, it might be data about diseases or conditions you have, and you can be sure that there are people really interested in that data, whether it's for marketing purposes or whether it's for insurance purposes or employment purposes, purposes that could have real consequences for the individual. And so there are real concerns about re-identification risk in those data. In terms of how easy it is to re-identify, I mean, I think that's an interesting question. I mean, the rarer the disease or the condition, the easier it will be to re-identify somebody within the data set, even if it has been stripped of identifiers, particularly if location is a factor or an element within the data set. And so you may actually be able to identify specific individuals in the data, even if you're not legally allowed to identify specific individuals in the data. And then, of course, it becomes a question of what companies do with this information, and that can lead to interesting ethical challenges as well. So, yeah, in the AI context, I think we have to accept that de-identification is not the most comforting privacy measure. Now, there are other people are working on other privacy-enhancing technologies to facilitate data sharing, because sometimes data sharing can be very valuable and important for research. So there's a lot of work going on around privacy-enhancing technologies. But de-identification in its own right, it shouldn't give us a whole lot of comfort anymore.
Trying to be gentle, but I kicked it. Are there models outside of the health information space that we could look to in terms of regulating the governance of information use? And I suppose a second question, if I may, in terms of enforcing these types of regulations, would this be a matter of expanding our information and privacy commissioners and expanding their jurisdictional control, or are there other approaches to enforcement?
Yeah, and that's a really interesting question, because in the context of AI, one of the interesting things about AI governance or AI regulation, the risk regulation, approach that we see in Europe, but that also we saw in the failed AI and Data Act in Canada, that type of regulation, in a sense, builds governance, other types of data governance into the governance of AI systems, so that if you're developing a high-risk AI system, and most healthcare applications would be considered high risk, there are certain steps that you have to follow. It wasn't clear what all of those would be in the Canadian legislation, because it was all going to be left to regulations, so we never even got that far. But there would have been some, and so typically those relate to transparency. They relate to documentation of what data sets are used, what steps have been taken to assure that the data is fit for purpose, which is really important. So it's issues of quality of the data, and that can include checking the data for bias and making sure the data is sufficiently representative. It can include monitoring across the life cycle of the AI system to ensure that the results that are being generated do not demonstrate systemic biases or other errors or other issues. So those are all important elements of governance, not just of AI technologies, but also of the data that use them, and those are part of AI risk regulation. Now, the AI and Data Act failed in Canada, it died on the order paper, and the current government has indicated that it has no appetite to reintroduce it. We can get into that if you like, but this is, that's an issue for Canada. Ontario passed AI governance legislation for the public sector and broader public sector, which would have included hospitals and universities, or which does include hospitals and universities, except that there is no content to that law. It's awaiting regulations which have yet to manifest themselves, and those regulations will determine whether what institutions it actually applies to and what the obligations will be. So we don't know yet. This is a very disturbing trend in Canadian lawmaking, where you pass fill in the blank laws, and then you do or don't fill in the blanks. Anyway, so that's one example of a province that's tried to do something like that. There are voluntary guidelines and guidance for AI developers that suggest some of these practices, but for the time being, most of those are voluntary in Canada. Larger corporations are putting a lot of work into AI governance themselves, especially if they plan to do business in Europe. So to some extent, they're looking at the EU obligations and about the potential to conform to EU obligations. So there's some governance work going on in the AI space. But I think that's an interesting place to look for that. And on the health privacy side, I think there's work that can be done to make those laws better at enabling uses of high-quality healthcare data that benefits society. So I think there's a lot of work that can be done in that respect, but I think governments have been struggling with that. But for privacy, and I guess when you mentioned privacy regulators, they're also struggling with that intersection between AI and privacy, because to the extent that there is no AI governance legislation, they're finding some of these AI questions coming up in privacy complaints, where people are complaining about privacy in relation to AI systems, and there may be issues of how their personal data are being used, but the essence of the complaint is really the effects of those systems on them, which may include discrimination or bias or other things, and the commissioners don't really have jurisdiction over that. So I think I'm starting to see in work coming out of privacy commissioners' offices and in some tribunal decisions, the struggles with the limits of their jurisdiction, but the desire to do something about it. So interesting times there as well.
We can probably take one more quick question. Okay. Thank you so much for this presentation. I just had a question about data annotations and data labeling. So with the rise in this AI systems, we are also seeing another type of companies coming out, which is like your Scale AI, which are specializing in data labeling and data annotations and stuff. And especially with health-related data, my biggest concern would be where that data is getting labeled. Is it happening inside the country, or are those companies sending that data out in like other countries? I know for a fact that Philippines is a very big hub for Scale AI for their data labeling operations. So how would we govern that? Like, what are some of the laws and regulations that govern those data labeling companies and data annotation companies?
Yeah, that's a really interesting question, because there's a lot that can go wrong with data labeling. It's a way in which certain biases can be introduced into the system and into the data. There are also there can also be significant regional and cultural differences that can go into data labeling as well. Although we see these issues with data across the board, so I mean, there's some interesting data sovereignty issues in how we acquire data for AI innovation and whose data is informing our AI innovation, particularly in the health space. I mean, if you think about data that is collected in, for use in affluent urban centers in the United States, that data may not map onto populations in more rural or remote areas in Canada, for example. And so how do you got to really think about what kind of data you're using. So those are all really big, complicated issues, and I don't think we have any solutions for that right now. Our ugly breakup with the United States has led, I think, to more discussions about data sovereignty and digital sovereignty in Canada, and so maybe that will become part of those discussions. But I do think that this issue of where the data come from, how the data are processed before being used in Canadian in AI systems for the Canadian context are really important questions.
Okay. We'll formally thank the speaker in just one moment. I just want to, first of all, say a quick thanks to our retired colleague, Mark Carter, who chaired the Speakers Committee before and has helped to set up wonderful events like this for this semester. Katie Richard, our events coordinator, and Danella Hoffman, our communications officer, who've played key roles in helping to get you all out here and make sure the event ran well. I'm going to invite forward our two student representatives on the Speakers Committee, Austin Goyer and Tyler Slaney, who are doing excellent work in helping us plan for future semesters, but they're also going to help to thank our speaker right now with a gift. And I don't know. And thank you to our speaker. You've brought us very contemporary issues and a really helpful lens on those. So thank you for what you've offered to us today.